He hasn't been the same since we lost Mom. My brother said it the way someone delivers a prepared statement, even unhurried, the conclusion already attached before the sentence began. He's withdrawn. He doesn't engage with practical matters. He sat in her house for 3 days after the funeral without sorting through anything. Frankly, we're concerned about his ability to make sound decisions regarding the estate. The mediator, a woman named Dorothy Haynes, had been sitting at the head of the table with the particular stillness of someone who has spent decades in rooms where people say things they can't take back. She had a yellow legal pad in front of her she hadn't written on since the opening statements. She looked past my brother, past his attorney, and let her gaze settle somewhere at the center of the table. "Counselor," she said, "before we move forward, has your client fully briefed you on his brother's professional history?" My brother's attorney, a man named Clifton, adjusted his tie. "He's retired," he said. "Former government work. Something in federal tax administration," we understood. Dorothy Haynes let a pause sit in the room. "Something in," she said. The conference room was on the 3rd floor of a building on High Street in Columbus, Ohio, and for one long moment, 5 of the 6 people in it went very still. "My name is Donald Mercer. I am 62 years old. I spent 31 years as a special agent with the IRS Criminal Investigation Division, the law enforcement arm, not the filing branch. My work involved following financial trails through shell companies, falsified records, and concealed accounts. I've built cases that resulted in federal indictments. I've been qualified as an expert witness in financial crimes proceedings more times than I can quickly count." My brother had described this to his attorney as something in federal tax administration. I sat at that conference table with my hands resting flat on the surface and said nothing. I've understood since I was a young agent that the most valuable thing you can do when someone is misrepresenting you in a formal setting is give them enough space to finish. 3 weeks earlier, my brother had filed a motion in the Franklin County Probate Court requesting that he be named sole administrator of our mother's estate, removing me from my position as co-executor. The motion cited my prolonged grief response following her death, my failure to engage in timely estate correspondence, and what his attorney described as my emotional inability to distinguish between sentimental attachment and practical estate management. My access to the estate accounts was frozen pending the court's review. Letters went out to the financial institutions holding my mother's assets, informing them of the dispute and requesting they hold all transactions. My name appeared in a probate filing alongside language about capacity and impairment for the first time in my life. My mother's name was Eunice May Mercer. She was 81 when she died. She had lived in the same house in Kettering, a suburb of Dayton, for 44 years, a small 2-story with a garden out back that she maintained herself until vascular dementia began making the details of daily life unreliable. She had raised my brother and me there alone after our father left when I was 11. She worked as a bookkeeper for a printing company for 26 years. She was precise with money the way people who've had to be precise are precise, checking her accounts every week, keeping a household budget in a blue 3-ring binder on the kitchen shelf. She wasn't wealthy. She was careful, and careful over a lifetime becomes something. When her decline began in earnest, my brother stepped in. He and his wife lived 40 minutes from Kettering. I was still working then, a caseload that didn't accommodate easy scheduling, and I told myself that was the reason I didn't drive down more often. I have had to sit with that telling since. My brother volunteered, and I was grateful in the way you're grateful when you haven't yet fully understood what someone's motives actually are. He drove my mother to appointments. He helped her sort her mail. He sat with her at the kitchen table and went through her monthly statements while she read the same paragraph of a magazine 3 times and pretended not to notice she was doing it. My mother trusted him because he showed up, and because trust for a woman of her generation was extended by default to family until something broke it. Nothing broke it visibly while she was alive. My mother died on a Tuesday morning in early February. I was with her. It was quiet. She had always been a quiet woman, and her dying was consistent with the rest of her. The probate filing arrived 6 weeks later. I remember sitting in my car in the driveway reading it twice, then a 3rd time, because the language had the kind of precision that only deliberate construction produces. Every phrase suggested without accusing. Grief-impaired judgment, failure to engage in timely estate administration, difficulty separating emotional attachment from sound fiduciary decision-making. Throughout, the implication was that I was a man undone by loss, unable to function in any capacity that required clear thinking. The irony didn't hit me sharply. It settled in slowly, the way realizations do when something you've been watching at a distance finally has a name. I sat in the car for a while. I didn't think about anger. I thought about sequence. There is a difference between being wronged and being positioned, and the motion filed against me had the structure of something prepared well in advance. Undoing it would require patience and the kind of documentation I had spent my career building. The next morning I drove to Kettering. My mother's house was exactly as she had left it. Not frozen dramatically, but tended, the way her home had always been. The dishes were dried and put away. The counters were clean. Her reading chair sat beside the lamp in the corner of the living room, with a paperback left face down on the armrest. The way she'd left it the last afternoon, she'd been well enough to read. I went to her bedroom first. She had kept her important papers in a fireproof lockbox in the closet, which I knew about because she'd shown it to me years earlier, the same way she showed me anything she considered important, once plainly without ceremony. The key was on her keyring, which was in the kitchen junk drawer, where it had always been. Inside the box were the documents I expected: her will, her insurance policy, the deed to the house, the original trust documents. There was also a sealed envelope with my name written on it in her handwriting from before the tremor got bad. Firm and even, the way she had written everything for most of her life. I set the envelope aside and looked at the papers spread across her desk. Something in the sequence wasn't right. A power of attorney document dated 14 months before her death that granted my brother's wife joint signing authority over all financial accounts. I had not been told this document existed. When my mother had talked with me about her estate plan 2 years earlier, she had spoken about keeping things simple, about leaving both her sons as co-executors of her will. Nothing she said then had suggested she intended to add my sister-in-law to her financial accounts. I photographed everything without moving it. Then I found the journal. My mother's occupational therapist had recommended she keep a daily memory log in the early stages of her dementia. A simple spiral notebook where she recorded what she did each day, who she spoke with, what she felt. The idea was that the practice of writing would help anchor her to the present. She had kept it faithfully. I knew it existed because she'd mentioned it once. I hadn't known where she kept it. It was in her nightstand drawer, underneath her Bible, and a small envelope of family photographs. A blue spiral notebook, about 180 pages, her handwriting filling every page in varying degrees of clarity depending on the day. I sat on the edge of her bed and read for 2 hours. Most of the journal was exactly what the therapist had intended. Records of small daily things, the weather, what she had for lunch, which neighbor had called, a note about her knee, but scattered through the entries from the final 18 months of her life were other things. Observations she'd written down because writing things down was, by then, how she made sure she remembered. She wrote about a day in October, 13 months before she died, when my sister-in-law had brought papers for her to sign at the kitchen table. My mother had written, "Didn't feel right about the papers, but she said it was for the taxes, and I trust her, sign them. Hope that was okay." She wrote about a day in March when my brother had taken her to the bank. She wrote, "They changed something with the accounts today. I don't know exactly what. I felt tired and didn't ask enough questions. Should have asked more." She wrote about a phone call with my brother in January. He told me Donald doesn't really think about me the way he should, that he has his own life and I shouldn't count on him. I don't think that's true, but it made me sad. I read that entry 3 times. At the back of the journal, clipped to the inside back cover with a binder clip, was a business card, an elder law attorney in Dayton. On the back of the card, in my mother's handwriting, called her, told her what happened with the accounts. She said, "Keep writing things down. Keep this card." My mother had known something was wrong. She had tried to leave a trail for someone to find. I photographed every page that mattered, left the journal in the drawer exactly as I had found it, and before I left, I opened the sealed envelope with my name on the front. She had written 2 pages. The handwriting was slower than I remembered, the pen pressing harder in some places, barely reaching the page in others. But the words were clear. She wrote that she had grown uneasy about some things in the final year and hadn't known how to bring them up without causing a fight. She wrote that she had always believed I noticed more than I let on, and that she was sorry she hadn't said so more often when she had the chance. At the end, she wrote, "I kept a little book like the doctor said. Everything I remembered I put in there. If it matters later, you'll know where to look. You've always been the one who knows how to read things other people stop reading. Trust that." I sat on the edge of her bed for a long time. When I left, I took the photographs and my mother's letter. The journal stayed exactly where it was. That afternoon, I called Maureen Solis. I had worked alongside Maureen on a federal financial crimes case 17 years earlier, when she was an assistant U.S. attorney. She had left the government and built a private practice in Columbus specializing in estate litigation and elder financial exploitation. She was exactly the kind of person you want when the other side has made assumptions about who they're dealing with. Maureen asked the right questions. She didn't interrupt. When I finished, she was quiet for a moment. They assumed you'd fold, she said. That's the mistake. People who file these motions against a grieving family member count on disorientation, not preparation. She asked what outcome I wanted. I thought about my mother writing in her journal that she'd sign things she didn't fully understand because she was tired and she trusted family. I want the record to be accurate, I said. I want what happened to her to be visible. Then we document and let the process do the work, Maureen said. Can you live inside their expectations for a few weeks? I told her I had spent my career working inside the frame of what people believed they'd gotten away with, watching, recording, waiting for the right moment. Over the following 3 weeks, I was exactly the man my brother had described in his motion. I responded to correspondence slowly. I deferred decisions when he called, I answered in short sentences and let long silences sit between us. I heard his voice settle into a particular register, not concern, but comfort. That comfort was important. People who believe they have won stop watching carefully. Maureen worked through proper channels with the kind of precision that comes from doing something for 20 years. She submitted a records request to all financial institutions holding my mother's accounts, using the estate dispute as the legal basis for full disclosure. She contacted the Ohio Adult Protective Services Unit that handled elder financial exploitation, providing the journal photographs and documentation sufficient to open a preliminary inquiry. She located the elder law attorney, whose card my mother had clipped to the back of the journal, who confirmed that my mother had called her 6 months before her death to discuss concerns about changes to her accounts, and who had kept a file note about the conversation with a timestamp. That attorney had been waiting to be asked. Then Maureen found where the money had gone. My sister-in-law had been routing transfers from my mother's accounts through her personal bookkeeping service, a small operation she ran out of their home, coded as home care and household management expenses. Some transfers were small, a few were not. The largest was a wire transfer of $41,000, made 8 weeks after the power of attorney was executed, described in the records as medical equipment reimbursement. My mother had no medical equipment purchased in that period. Her medical records confirmed it. There was also a beneficiary change form on my mother's life insurance policy, executed 11 months before her death, redirecting 40% of the policy from a split between my brother and me to my sister-in-law alone. The form had been signed on a day when, according to my mother's own journal, she had written the wrong month twice in the same entry and had noted at the bottom, "Hard day, not feeling clear." The night before the mediation, I drove to Kettering. I didn't go inside. I sat at the curb under the maple tree in the front yard and watched the porch light come on the way it always had, on a timer my mother had set years ago and never changed. I thought about her journal, about the small, careful sentences she had written on her clear days, and the looping uncertain ones on the hard ones. I thought about the business card clipped to the back cover, the 4 words in her handwriting, "Keep writing things down." She had known something was wrong. She had done what she could. In the conference room the following morning, when Dorothy Haynes asked her question and the room went still, I understood that we had arrived at the moment my mother's quiet records had been waiting for. Maureen rose without urgency. She placed one hand flat on the table and spoke to Dorothy Haynes in the tone of someone with nothing left to prove. "The motion before this body rests on a claim of impaired judgment," she said. "What I intend to demonstrate is that the estate's financial irregularities occurred entirely during the period when my client had no access to his mother's accounts, and that the individual now claiming my client lacks capacity has spent 14 months transferring estate assets under cover of caregiving expenses." She began with the timeline. Account statements, first on the table, then on the screen at the end of the room. She walked through each without drama: balance before the power of attorney, balance after, corresponding transfers, their stated descriptions, and whether supporting documentation existed. She pointed to the inflection point, the month the POA was signed. Before it, 22 years of consistent, modest financial behavior. After it, a pattern of transactions with no documented basis in legitimate expenses. My brother's attorney objected. Dorothy Haynes overruled him before he finished the sentence. Maureen moved to the power of attorney itself. She did not call it fraudulent. She noted the date it was signed, the medical records from my mother's physician showing she had presented at his office 3 days. Prior reporting increased confusion and disorientation, and the fact that no independent attorney had been present at the signing. She noted that the scope of authority granted was substantially broader than what my mother's own estate plan had contemplated in documents drafted 2 years earlier. My brother's wife stared at the table. My brother crossed his arms. Maureen paused. I'd like to offer some context about my client's professional background. She looked at me. Would you describe briefly what your career involved? I stood up. I said, I spent 31 years as a special agent with the IRS Criminal Investigation Division. My work involved identifying irregular financial patterns in individual, corporate, and estate records. I have been called as an expert witness in 38 federal criminal proceedings involving financial crime. I retired 2 years ago and continue to consult on active cases. Dorothy Haynes removed her reading glasses. She looked at me directly. 38 proceedings? 38, I said, give or take. She turned to my brother's attorney. Counselor, was this professional history considered when your client prepared this motion? His attorney hesitated. We understood his background was generally related to government tax work. Generally related, Dorothy Haynes said. My brother stood. His voice had the edge that appears when someone feels a room shifting out from under them. He wasn't there. He was never there. Mom knew it. She told us. He had his career and his life, and he let us handle everything, and now he wants to walk in and act like. Sir, Dorothy Haynes said quietly, sit down, please. He sat. His jaw was tight. Maureen continued without acknowledging the interruption. She presented the APS inquiry documentation, not conclusions, just the fact of a formal inquiry now on record. She presented the $41,000 wire transfer and the absence of supporting documentation. She presented the beneficiary change form alongside the medical record showing my mother's condition 3 days prior. She presented a statement from my mother's neighbor, a woman named Wanda who had lived next door for 19 years, describing an afternoon she had observed my sister-in-law arriving with papers on a day my mother had called her that morning to say she wasn't feeling herself and could use some company. Then Maureen placed my mother's journal before Dorothy Haynes. She didn't read from it at length. She described its nature. A daily record kept on a therapist's recommendation, and noted its start date, its end date 3 weeks before my mother's death, and the existence of the elder law attorney's business card clipped to the back cover with my mother's own note on the reverse. She read 4 sentences from specific entries. I had chosen those 4 sentences with Maureen the night before, so they would land without requiring emphasis. The room was quiet while Dorothy Haynes read the relevant pages herself. When she set the journal down, she folded her hands. Mr. Mercer, she said, you've been largely quiet this morning. I'd like to ask you one direct question. Of course, I said. When did you first suspect there were irregularities in your mother's accounts? I had concerns in the months before her death, I said. The motion filed against me confirmed those concerns and gave me legal standing to formally document what I'd suspected. She nodded slowly. So the motion effectively gave you grounds to pursue what you'd already seen. Yes, I said. Dorothy Haynes was quiet for a moment. Then she turned back to the table. The motion is denied, she said. Given the documentation presented and the inquiry now on record, I am also submitting a formal referral to the Franklin County Prosecutor's Office for review of the transactions at issue. My brother's wife said something low to him. He didn't respond. Outside, Maureen and I waited for the elevator. She said what she said after every hearing like this one. The first part is finished. The rest takes longer. I told her I was familiar with longer. The consequences arrived in stages rather than all at once. Within a week, the financial institutions involved had received formal requests from the prosecutor's office. They cooperated quickly. Banks respond when the paperwork is correct, and Maureen's paperwork was always correct. A full transaction audit was ordered for the entire period covered by the power of attorney. The results had the shape I had been expecting. The $41,000 wire transfer with no supporting documentation. Smaller transfers coded as groceries and household expenses across 14 months, the beneficiary change on the insurance policy, and a home improvement account my sister-in-law had opened in her own name with funds transferred from my mother's checking account. The total wasn't the largest figure I'd ever encountered in my career, but it was the figure from my mother's life. From 44 years of bookkeeping income and careful management, from a woman who had checked her accounts every week and kept her budget in a blue binder on the kitchen shelf. My sister-in-law retained counsel within 2 days of the referral. Her attorney entered cooperation discussions with the prosecutor's office the following week. My brother hired a second attorney after his first one withdrew. The new attorney had less to work with. The financial records were thorough. My mother's journal was admissible and clear. The neighbor's statement had dates and specifics. The elder law attorney's file note had a timestamp. The medical records bracketed the POA signing. A paper trail closes exit doors one at a time, without urgency, and this one was thorough. My brother accepted a plea 8 months after the mediation. My sister-in-law entered her own plea 2 weeks later. The charges fell under Ohio's statute on financial exploitation of a vulnerable adult. The sentence reflected the seriousness of what had been done without the weight of physical harm. Probation, full restitution with interest, and a permanent prohibition on serving in any fiduciary or financial representative capacity for another person. To satisfy restitution, several assets were liquidated, including a lake cottage in southern Ohio that my brother had mentioned to me once as an investment they were considering and that I had never followed up on, because I had been doing what I had been doing for most of my adult life, watching carefully, saying little, and trusting that what I couldn't yet prove wouldn't remain invisible forever. I was wrong about the last part. Things stay invisible when you allow them to stay invisible. I had let too many miles and too many busy years accumulate between my mother and me, and someone had used that distance. That part is mine. I've been carrying it. My daughter called 2 days after the mediation. Her voice had the evenness she uses when she's working to keep it steady. "I saw the filing in the court records online," she said. "Grandma used to mention sometimes that you didn't visit enough. I always thought that was coming from somewhere else, but I never said so." I told her she hadn't known it was significant. "I knew it felt off," she said. "I just didn't want to start something." "That's understandable," I told her. She was quiet for a moment. Did she know someone would figure it out? I thought about the business card clipped to the back of the journal, the 4 words written on the reverse in my mother's handwriting. "She did what she could," I said. "She left what needed to be found." My daughter made a sound that was somewhere between a short laugh and something harder to classify. "That is so completely her," she said. "It is," I agreed. She came to visit in March. We had dinner at the kitchen table and talked for a long time about her work, about a trip she was planning, about a neighbor of mine she'd met once and found funny. Before she left, she hugged me in the doorway a moment longer than usual. "I should have called more," she said. "So should I told her. She nodded. That was enough for now. My brother called 4 months after the plea. It was a short call, and his voice was smaller than it had been in the conference room. He said he hadn't realized, a phrase that ran out of credibility somewhere around the middle. I let him finish. I told him I didn't need him to understand right now, and that when he was ready to talk plainly, I'd be available. We hung up. I don't know what comes next for us. What I know is that distance has a cost I didn't account for, and that the people who filled that distance did not fill it well. That is a lesson I should have learned before I needed to. I sold my mother's house in Kettering the following autumn. On the last day before closing, I walked through the empty rooms one more time. The furniture was gone. The blue binder had been taken from the kitchen shelf months ago when I cleared her papers. The garden out back had grown into itself over the summer, unharvested. I stood in the kitchen where she had done her weekly accounts, and I thought about her sitting at this same table in the evenings, writing in her journal, recording what she could while she still could. I had the journal with me. I had carried it since the day I found it. I stood at the kitchen window and read the last entry she had written in her clear handwriting 3 weeks before she died. Today was a good day, quiet. Sat in the garden for a while, looked at the tomatoes, thought about both my boys. I love them both even when things are complicated. Things are always complicated at the end. That's all right. I folded the journal and put it back in my coat pocket. I closed the back door and stood on the small porch for a moment in the October air and let myself feel what I had been too careful to feel for a long time. Not triumph, not exactly relief. Something simpler. The quiet that comes from having done what needed to be done in the only way it could be done, without needing anyone to notice. The closing documents arrived by mail the following week. I signed them at my kitchen table with a cup of coffee going slightly cold beside me and sat there afterward looking at nothing in particular. Outside, someone was raking leaves. A car passed on the street. Ordinary sounds returning. My mother used to say that keeping good records was a form of respect for your own history, for the people who come after you, for the truth of what actually happened. She said it once, the way she said anything that mattered, plainly, without repetition, in the expectation that you'd been paying attention. She was right. Records don't forget. They don't revise themselves to protect the people who are afraid of them. They hold what happened and they wait. And eventually, someone who knows how to read them comes along. I pushed back from the table and stood up slowly, the way you do at 62 when your knees have their own schedule. I carried my coffee to the window and stood there for a while, watching the street settle into a quiet afternoon. If you've ever been written off by someone who mistook your stillness for absence or your patience for weakness, I'd like to hear from you. Tell me where you're listening from. Tell me what the weather is like there today. These are the stories that matter, and I have more of them.